Today, we are joined for this week's segment of Everybody Has a Story by Professor Akhil Amar, who is the Sterling Professor of Law and Political Science at Yale University. He is an expert in constitutional law, having been cited in over 20 Supreme Court cases. And he is the author of multiple books on the United States Constitution, including America's Constitution, a Biography, and most recently, America's Unwritten Constitution, the Precedents and Principles We Live By. Professor Amar, thanks for joining us.
Thanks for having me.
So there's this two big cases that were just argued before the Supreme Court concerning a very hot button issue, same-sex marriage.
Yep.
Before we get into the specific oral arguments and the specifics of the cases, I just want to start very broadly. Is there a fundamental right to marriage?
Absolutely. The Supreme Court has recognized marriage as a fundamental right in over a dozen cases. I think I heard the number 14 a couple of times mentioned as the number of citations in Supreme Court case law to the fundamental nature of marriage as a right. And this is a reminder that not all fundamental rights are expressly enumerated, are listed in the Constitution. That's partly what I was trying to talk about in the Unwritten Constitution. The Ninth Amendment says that we shouldn't deny or disrespect rights that aren't enumerated. The 14th Amendment, rights of the people. The 14th Amendment says that there are privileges and immunities of citizens that no state should abridge, but it doesn't itemize all of those rights, and so we have to figure out what those privileges and immunities of citizens are, what those rights of the people are, and here's one we can find out what they are. We can look to how the people actually think and live. So the Constitution doesn't say explicitly there's a right to be married, doesn't say there's a right to have a pet dog, to play the fiddle, to wear a hat, to relax on your porch in your home, but all of those rights and many more are exercised by ordinary Americans in their daily lives, and some of these rights have evolved, have changed over time. I'll give you one example and we can go back to marriage. At the time of the Constitution, no defendant in a criminal case could testify in his own behalf. In no court was he allowed to do that, state or federal. Practices changed state by state, and eventually the Supreme Court said, we now recognize a fundamental right of every criminal defendant to testify in his own behalf. Every justice today recognizes that right, left, right, and center. Justice Scalia and Alito, in fact, that was the basis of Justice Alito's very first ruling for the Supreme Court, is a fundamental right of a criminal defendant to testify in his own behalf, a right enjoyed by no criminal defendant when the Constitution was adopted. So yes, there are unenumerated rights. Marriage is one of them. It's not the only one.
Well, that you mentioned the 14th Amendment, and that leads right into this first big case, which is Hollingsworth v. Perry, concerning the California ballot initiative, Proposition 8. The Ninth Circuit Appeals Court upheld the district court's ruling, saying that this was a violation of the due process and equal protection clauses in the 14th Amendment. So this brings me to an obvious, simple question. Do you agree? Is this an equal protection violation, excluding same-sex couples from marriage?
I think there are actually at least three reasons for believing in a right to same-sex marriage. One is that laws that discriminate against same-sex couples discriminate on the basis of sex. If I want to marry Leslie, I'm allowed to do so if Leslie is a woman, but I'm not allowed to do so if Leslie is a man, and that is simple, formal sex discrimination, which under our jurisprudence should be treated as requiring a very special burden of government justification. Government can't lightly engage in sex discrimination. Sometimes it's okay. Government can say boys' gym classes over here and girls' gym classes over there, separate showers, separate bathrooms, separate sports teams. But in a lot of other contexts, we don't allow government to discriminate on the basis of sex. That's one basis for being very skeptical about opposite sex only marriage.
So that would be strict scrutiny, right?
That would be heightened scrutiny. That would be, the court has called it intermediate scrutiny, but heightened scrutiny. A second basis is that these laws that allow only opposite sex couples to marry discriminate on grounds of sexual orientation. And that's not right and fair, especially if you think that people are born with a certain sexual orientation. In the same way that people are born male and female, black or white, many people believe that one might be born gay or straight. And if so, laws that in effect permit straights to marry but not gays to marry violate this idea of birth equality. No distinctions that really that discriminate and that give second-class citizenship to people because of the way they're born, because of their birth status, in this case sexual orientation. The first argument is just straight up sex discrimination, treating men and women differently in a certain formal way. This is an argument that this treats gays differently from straights. The third argument is a more full-blown liberty argument. The first two were equality arguments. The liberty argument is simply there's a fundamental liberty interest in marrying the person of your choice. That's part of the pursuit of happiness. That's part of American liberty. It's an unenumerated right. The tricky thing about that one is why not polygamous marriages? Why not three-person and four-person marriages? Why not polyandry, Bob and Carol and Ted and Alice? One argument is that this fundamental right to marry should pay attention to actual societal norms, to evolving state practices. We are in a world where many states now are recognizing gay marriage. Many countries around the world are, but especially many states, and many more will very, very soon. On this issue, one question is the timing right? Should we wait a little bit longer, wait for more states to recognize this fundamental right before it's judicially announced? So on that, and even on the equality argument, so there's these three arguments, two equality arguments and a liberty argument. One could worry that for a judge to announce these rights now might risk a certain kind of backlash, might actually undercut the very principles that we're trying to protect by allowing critics to bring up the issue of judicial activism, to change the subject from equality. Equality is winning state by state. It's winning in the public. It's winning in general discourse between
that's
citizens.
What Justice Ginsburg was talking about with Roe v. Wade. Right?
So there is a
the
possibility,
backlash.
not because judges are sort of wimpy and shouldn't enforce rights, but because instead, if you enforce a right before the public is ready for it, you might actually hurt the very people you're trying to protect. That's a legitimate, realistic factor to be considered in the analysis.
Now, the argument to me, would you call those originalist arguments? Because I think, so there was one of the tense moments during the oral arguments for Hollingsworth v. Perry was Ted Olson, one of the lawyers, was arguing with Justice Scalia. And Justice Scalia asked him a very pointed question, which was, when did excluding same-sex couples from getting married become unconstitutional? And there was a little back and forth, but in the end, Ted Olson kind of stumbled. He didn't really have a good answer for Justice Scalia. He kept saying, there's no date, it's evolved.
He had an answer, but Justice Scalia kept cutting him off. His answer, in effect, was to answer a question with a question. Let me ask Justice Scalia, when did criminal defendants get the right to testify in their own behalf? Because at the founding, no criminal defendant had that right. At the 14th Amendment, which is after the Civil War, almost no criminal defendant had that right, and yet you, Justice Scalia, have signed on to that right. Well, when did that happen and why? When did a right to have appointed counsel emerge? And I think the honest answer is that the court itself has said in a series of cases, we look to actual state practices as evidence for the emergence of new rights. At the founding, you didn't have all felons did not have a right to appointed counsel, but by the time of Gideon versus Wainwright, 1963, we mark its 50th anniversary this year, 45 of the states did recognize such a right. At the time of the founding, to repeat, no criminal defendant had a right to testify in his own behalf, and after a certain point, almost all states recognized that right, and the Supreme Court constitutionalized it and universalized it. At the time of the founding, almost all the states had laws prohibiting certain forms of intimate sexual conduct, sodomy, anal sex, for example. But by the time of Lawrence versus Texas, in I think 2003, almost all the states had abandoned that practice, and based on that, the Supreme Court said there's now a fundamental right to engage in these forms of intimate sexual conduct. Justice Scalia dissented in that case, and in his dissent, he actually said, well, the meaning of this case is gay marriage. So Justice Scalia, in fact, said in 2003, we've just done something that's going to lead to gay marriage. So he himself, in 2003, gave that date.
Well, I think in his dissent, he talked about, he said, believe me, I'm not, I have nothing personally against gays and lesbians, but we are being impatient. I think the quote was impatient to democratic change. Is the court, if they make a sweeping ruling about gay marriage, is the court being impatient of democratic change that is going on and extrapolating something that's not actually in the original text?
Well, it's a fair question. Let's work through the different elements. One big question is how we count the nature of how we measure democratic change. If you look at number of states, only 9 recognize same-sex marriage. Should we factor in the population of the states? Should big states count for more than small states? And if so, how might that affect the analysis? Are the states that have recognized it bigger or smaller than average? Should we look not just at laws on the books, but how the laws are actually enforced? It turned out that there was a time in American history when a lot of laws criminalized same-sex behavior, but those laws were almost never enforced against private consensual conduct. Should we look at just the number of laws or how they're actually enforced? Should we look at poll data? And here it's very dramatic because the American people are way out ahead of actual state practice. In California in 2008, they voted for Proposition 8 that said no gay marriage, but I'll give you 5-to-1 odds that if California, I'll bet a lot of money, that if California were re-voting today, they would vote for same-sex marriage. In fact, they voted for Jerry Brown, a Yale Law School graduate, as their governor, and Kamala Harris, their attorney general, who ran on a platform that they wouldn't enforce Proposition 8. That was a more recent election. So one question is, if we're looking for unenumerated rights, rights of the people, how do we measure what the people think and believe? Number of states, laws as they're actually enforced, poll data, and Scalia might say, well, the polls might change. I don't think so. I'm willing to bet him a lot of money because people your age believe in gay rights and they're not going to change. And the people who don't believe in gay rights are basically Justice Scalia's age, and newsflash, they're going to die first. So we're not going back on this. It's going to happen. As I said, I'm willing to bet you a lot of money on that. But should judges take that into account when defining unenumerated? That's a fair question. But let's put unenumerated rights to one side for just a second. There are also, because those depend on their strength in society. But there are also enumerated rights, and there are enumerated rights to equality. The 14th Amendment already says equality, birth equality. The 19th Amendment adds a very important focus on sex discrimination. That's the one that provides for women's suffrage. Now, if the 14th Amendment says no one should be discriminated against because of how he's born, and I think it does say that, and if we now believe that people are born gay and straight in a way that maybe we didn't understand that 30 or 40 years ago, then that's already in the Constitution. Maybe we have a new social scientific fact that we've come to understand. And Ted Olson began to say that too in his response to Justice Scalia before he got cut off.
Now, I just for time's sake, I want to move to the DOMA case. So this Defense of Marriage Act case, U.S. v. Windsor, was argued on Wednesday,
Yes.
yesterday. And there are over 1,100 federal provisions that use this definition of marriage and consequently deny same-sex couples from benefits in taxes, family medical leave, Social Security, you name it. Justice Kennedy had an interesting point when he talked about DOMA. His problem was more with federalism.
Exactly.
He said, you are at a real risk, quote, you are at a real risk of running into conflict with what has always been thought to be the essence of the state police power, which is to regulate marriage, divorce, and custody. Is he right here? Do states, and only states, have the prerogative to define marriage for themselves? And if so, would that make any federal definition of marriage, even if it includes same-sex couples, run into federalism problems?
I love Justice Kennedy on a personal level. I count him a close friend. He's been extremely generous to me and my family, but I respectfully disagree with his federalism objection. And you put your finger on it. What if Congress passed a civil rights law, human rights law, saying we recognize same-sex marriage, and not just for federal purposes? Suppose they went even further, said not only do we recognize federal marriage for Social Security and income tax and veterans purposes, and military and federal military purposes, we insist that every state recognize same-state marriage because we think there's a fundamental right to same-sex marriage under the 14th Amendment, under our power to affirm civil rights. I would think that Congress has that power. Justice Kennedy has been more skeptical of congressional power to vindicate human rights under the Reconstruction Amendments. So if DOMA is a problem, I think it's a problem because it violates equality, not because it violates federalism. This idea that DOMA should be struck down because it's a weird federal law, we don't see federal laws like this otherwise, that's the same theory that Justice Kennedy used to vote against Obamacare, and I respectfully disagreed with his critique of Obamacare. The fact that a federal law is sweeping or unusual doesn't make it unconstitutional. Before we had Social Security, we didn't have Social Security. Before we had Medicare, we didn't have Medicare. So I'm not opposed to new federal laws just because they're new federal laws, and I don't buy the federalism objection. I do think the equality objection is very powerful.
Now, does there need to be uniformity in both these decisions, Windsor and Perry? Because Tom Goldstein, who's a lawyer in D.C. and founded SCOTUS blog, made an interesting assertion about the motives of the conservative justices. He said, in fact, there is a realistic chance that the court's most conservative justices understood that dynamic from the beginning about these two issues clashing, essentially. That if you invalidate Proposition 8, and you invalidate DOMA, that there's a contradiction there, and you can't do both. And that if Justice Kennedy ends up invalidating DOMA, which it looks like he wants to do, he's going to have a problem with Proposition 8, and that may have been why he was looking for an off-ramp with the standing issue.
Well, let me step back and talk about what the world is going to be in 10 years. Regardless of what happens this year, I believe that the forces supporting same-sex marriage are winning, will win, and we will have soon enough same-sex marriage everywhere, regardless of what the Supreme Court does, even if it doesn't do anything to help gay rights, because California is changing its policies even without any prodding from the Supreme Court. The governor isn't enforcing this ban on same-sex marriage, and neither is the Attorney General. And if we put it to the people of California a second time, they will vote to affirm same-sex marriage, and so will people in all sorts of other states. And then it won't be 9 states; it'll be 10, and then 20. And at a certain point, the tide will turn. And when it's 30, when it's 40, Justice Scalia isn't going to be able to say we're being impatient, blah blah blah, because the tide will have turned. Just as with Gideon versus Wainwright, just as with the right of a criminal defendant to testify on his own behalf, enough states will have done it. And here's the real kicker on DOMA. Forget Section 3 of DOMA, which is about how the federal government defines marriage. The real issue is Section 2 of DOMA,
Which protects the states.
which is about whether Texas is allowed to not recognize a marriage, say, entered into by two Texans who go off from Austin to Boston for a weekend, get married in Boston where it's legal, and then come back to Austin. And if states are going to have to, as a practical matter, recognize marriages celebrated by other states, you're going to have same-sex marriage nationally very soon, and that's the thing to keep an eye out.
That kind of brings me to the wrap-up of this, which is predictions. You know, what's going to happen. So the Kennedy seemed to have problems, like I said, with DOMA for federalism reasons. The liberal justices believe that it's an equal protection violation. So.
And the weird thing there is that there could be 5 votes against DOMA, even though there's actually a majority for neither theory.
Yeah.
Only 4 people think it violates equality. I'm with them, but only 4 people do, so a court majority might reject that theory. 8 of the 9 might think the federalism objection of Justice Kennedy is not well taken, and so even though both theories against DOMA actually lack a Supreme Court majority, 4 plus the 1 could equal DOMA's invalidity, even though there's no sort of coherent single theory for that. That could happen.
Is that what you predict? Do you predict that DOMA entirely is going down, or just Section 3? And in the same regard with Hollingsworth v. Perry, is this going to be a kind of anticlimactic case where they're just going to say, no standing, come back next time?
I don't expect a sweeping ruling in the California case. I do think that they could simply say that the people who are trying to defend Proposition 8 in court aren't really the right people. They don't have standing, and so just back to square one, send it back to the courts in California. So that's quite possible. DOMA Section 3 could be struck down with a kind of an odd alignment of 4 liberal equality votes and 1 quirky but important, Justice Kennedy in the middle, federalism vote. And the interesting question is whether the rest of DOMA will fall, or whether instead the justices will say, oh, Section 3 is different from Section 2, we don't reach the Section 2 question. But going forward, one of the most important questions is going to be, now that a whole bunch of states recognize same-sex marriage, don't the other states have to treat those marriages as valid? When you are traveling down I-95, you were married in Massachusetts, so you go through Rhode Island and then suddenly you're not married, and then back in Connecticut, okay, you're married again, and then New Jersey, you're not married again, and then you get down to Maryland, you're married again. Is that how it's going to work?
Professor Amar, thank you for joining us.
Thank you, pal.
And thank you for joining us. I'm Cody Pomeranz. This has been YTV. Everybody has a story. Back to you in the studio.